Good afternoon. My name is George Pattis. I'm an assistant United States attorney here in Dallas and a chair of the 2021 Trial Skills Committee for the Dallas Association of Young Lawyers. If this is your first Trial Skills Committee program, welcome. Today is the first of 3 events in our 2021 Trial Skills Boot Camp series, where we try to give young lawyers practical examples and opportunities for experiential learning by doing with some of Dallas's best attorneys and judges. Today's program on arguing before the court is a great example of truly outstanding members of the Dallas Bar and Bench, providing real practical examples and advice. The theme for this year is modes of argument, making your case to a judge, jury, or appellate panel. So we'll not be focusing on a specific portion of trial or discovery or anything like that. Instead, we'll be focusing on how to argue in front of a judge, how that's different from arguing in front of a jury, and how that might be different from arguing before an appellate panel. Today's program will focus on arguments to the court before trial. The next events will focus on jury and appellate arguments in the summer and fall, so stay tuned. We'll provide information about future events at the end of today's program. CLE information will be provided in the chat. During the program, we will be monitoring the Q&A, and we'll attempt to weave answers from questions from attendees. At this point, let me briefly introduce our panel of speakers and demonstrators before we do a mock argument of a TRO, followed by a panel discussion. First is District Judge Tanya Parker. Judge Parker is a Dallas District Judge in the 116th Judicial District Court, a position she has held since 2011. She has been elected by her judicial colleagues twice as the presiding judge for the Dallas County Civil District Court. She's also served as the president of the Texas Association of District Judges. She is a member of the American Law Institute and serves as an advisor to the ALI's Restatement of the Law Third Torts Remedies Project. Judge Parker is consistently recognized for her performance and temperament on the bench. In the Dallas Bar Association's judicial evaluation polls for 2019 and several other years, her overall approval ratings exceed 92% and are among the highest ratings of judges evaluated in the polls. Outside of her work on the bench, she devotes countless hours to bar and civic events across the country. Over the last decade, she has been a regular volunteer with Ignite, a nonpartisan organization aimed at building political ambition and training young women to run for public office. She has also served on numerous other legal and civic boards and commissions. We'll also be joined by United States Magistrate Judge David Horan. Judge Horan was appointed and sworn into the Dallas Division of the Northern District of Texas on November 21st, 2012. Before becoming a magistrate judge, he was a partner in the Dallas office of Jones Day, where he led the firm's issues and appeals practice group in Texas. Judge Horan graduated from Yale Law School and served as a law clerk to the Honorable United States District Judge Janet Hall, and as a law clerk to the Honorable United States Circuit Judge Patrick Higginbotham on the United States Court of Appeals for the Fifth Circuit. For the practitioners, we're joined by Elena Ackles, a partner with the Dallas office of Bell Nunnally, who focuses on labor and employment, as well as complex business disputes in state and federal court, as well as arbitration. In addition to her extensive litigation, focus, and deep experience, she counsels clients on labor and employment matters and trains management and human resources professionals on a wide range of employment topics. She has been regularly rated by her peers as a rising star and listed among the 40 under 40 by D Magazine and the Dallas Business Journal. She also serves on the Leadership Council on Legal Diversity and a mentor on DAYL's Women Mentoring Circles, among her other many civic and bar contributions. Raghi Dunn is a partner and the founder of the Raghi Dunn Group law firm. He has tried cases to verdict or award in 7 different states and 12 cities in Texas. He has represented clients in disputes arising in Brazil, Canada, Mexico, Scotland, England, Qatar, and 26 states within the United States. He has been recognized by D Magazine as one of the best lawyers in Dallas 12 times. He represents both corporate defendants and plaintiffs, and his total plaintiffs' judgments have netted more than $2 billion for his clients. He graduated from the University of Texas School of Law, where he served as a notes editor on the Texas Law Review before clerking for United States Circuit Judge, the Honorable Reynaldo Garza on the United States Court of Appeals for the Fifth Circuit. Mr. Dunn is also an avid collector of art and memorabilia, and portions of his award-winning art collection have been displayed at the Hall of State of the Texas State Fair and are on display on extended loan to the Frontiers of Flight Museum. Welcome all of our panelists and presenters. As I mentioned before, we're going to begin today with a mock argument on a temporary restraining order. Judge Parker will be the presiding judge. Elena Ackles will be plaintiff's counsel for Plaintiff Dolores, an employee who left Mask Up for its direct competitor, Cover Your Mouth, or CYM. Raghi Dunn will serve as defense counsel for Mask Up, who is seeking a TRO to enforce Dolores' employment agreement, specifically the covenant to not compete or solicit customers. Elena and Raghi will be modeling best and worst practices for teaching purposes. So please don't hold their conduct at the mock hearing against them. Judge Parker.
Thank you. Counsel, let's begin in cause number 21-13579. This is the matter styled Dolores Hampton versus Mask Up LLC et al. This morning, the court has before it a request for a temporary restraining order, which I understand will be presented by you, Mr. Dunn, on behalf of the defendant counter plaintiff, who is the applicant on this request for a restraining order. You will have 6 minutes to make your initial arguments to the court, and then Ms. Ackles, on behalf of the plaintiff counter defendant, will be given the opportunity to respond for 8 minutes. And since you carry the burden here, Mr. Dunn, I will come back to you for a final rebuttal of a couple of minutes. Counsel, you may proceed with your arguments.
Your Honor, if you wouldn't mind, it would please the court, I'd like to split my argument 4 minutes and 4 minutes in rebuttal, and I've talked to opposing counsel. They have no objection.
That'll be fine, counsel. Thank you.
And then one last indulgement, if you could notify me when I have 1 minute left for those 4 minutes. Your Honor, this is a clear case of a former employee misappropriating and misusing trade secrets. It's information that the former employee gained only by receiving, and importantly, using the client list of Oldco to access that list and actually solicit Oldco's clients when the former employee worked there. Then the former employee goes to work for an arch rival competitor of Oldco, my client, and immediately starts soliciting the clients that the former employee learned of and solicited at Oldco. Listen to this. The former employee didn't wait 6 months to start the solicitation. She didn't wait 6 weeks. She didn't wait 6 days. Literally the very next day, when the former employee starts at Newco, she sends out a solicitation. And this wasn't a subtle solicitation of, I've left Oldco and I'm going on to new adventures, or I've left Oldco and I'm going to be starting at Newco. Instead, it was a full frontal and direct solicitation. Let me give you some examples. One, she said she's leaving Oldco, and then she touts, praises, and promotes Newco. She provides her new contact information, not her personal contact information if somebody was a friend, but her business contact information at Newco. She provides a statement saying, I'm leaving and I look forward to keeping in touch. That had a devastating impact on Oldco. Guess what happens when the former employee goes to work for our arch rival competitor? In violation of non-compete, within 30 days of starting with Newco, all right, guess what happens? Our top customer does not renew a $50 million contract. Instead, Oldco's top customer enters into a $100 million contract with the arch rival competitor. So within 30 days, we have a seismic shift of our best customer and we lose a $50 million contract. Coincidence? I think not. Now, let me show you and share with the court a document showing you the 4 keys to this case. Can everybody see those 4 keys, counsel?
Yes, you may proceed.
There are 4 keys here. While at Oldco, Hampton, the plaintiff, used our database, Oldco's database, to send emails to current and potential masked up clients. And this is important. These are clients she did not know, did not have a relationship. Second, The very second day that she's working for the arch rival competitor, she sends out this email that I mentioned, a blast email soliciting business from all masked up customers she interacted with and was introduced while employed by Mask Up. Okay. And she says, I look forward to keeping in touch. Third key point, this violates the non-compete that she agreed to, which says she will not provide garment design services in any territory in which Mask Up has ever solicited or sold garments. Fourth, it violates the non-solicit. She agreed, I will not solicit garment design services from anyone I contacted regarding garment design services in the last 2 years that I worked for Mask Up. Okay, now let's go to the
Counsel,
smoke.
pardon me, but you have 1 minute remaining.
Thank you. So there's a smoking gun. A lot of times we don't find these smoking guns until we take a deposition or we dig through thousands of pages of electronically stored information. In this case, the smoking gun is right there from the get-go. Look at the chronology here, Your Honor. April 1 of 20, my client signs a $50 million mask contract. Then on March 1, 21, Hampton, the plaintiff in this case, starts with Cover Your Mask, our mask competitor. And looky there, 1 month later, the Cover Your Mouth gets the 100 million mask contract, and we do not get our mask contract renewed. So when I said devastating impact, I was not exaggerating. Within 30 days of the plaintiff starting work for our arch rival competitor, we lose a $50 million contract. And guess who gets it? The company that she went to work for that is our competitor in direct violation of her non-compete. And on top of that, we have a non-solicit. In addition to the relief we're asking, Your Honor, we have filed a motion for expedited discovery. We want the plaintiff's deposition in the next 10 days, as well as the documents that we've requested. Thank you.
All right. Thank you, Mr. Dunn. And when I come back to you after giving Ms. Ackles an opportunity to respond, I will be wanting to visit with you about why, given what you've set forward in terms of the loss of the contract, why there's not an adequate remedy at law with the award of money damages. Ms. Ackles.
Thank you, Your Honor. A few key facts to set the stage for this argument. First, Mask Up's business is related to the manufacture and distribution of masks only, no other garments. Number two, Ms. Hampton's, before she joined Mask Up, had a very successful career doing enhanced bedazzled jeans. And three, her current role at CYM is leading their new bedazzled jeans venture and has nothing to do with masks. That being said, Your Honor, as you're aware, in order to prevail and obtain the extraordinary relief of a temporary restraining order, the plaintiff in this case, or counterclaimant, I should say, Mask Up, has to prove a substantial likelihood of success on the merits on their breach of contract claim. And Your Honor, they simply cannot do this in this case, and the request for the temporary restraining order should be denied. As you're aware, restrictive covenants in the state of Texas are enforceable so long as they're reasonably limited and they're not more broad than necessary to protect the legitimate business interests of the company, of Old Coal. In this case, the non-compete and the non-solicitation agreements, Your Honor, are overbroad and should not be enforced, and therefore the TRO should be denied. May I share my screen with you, Your Honor?
You may.
The restraints on trade in this case, Ms. Hampton concedes that the restraints as to time are reasonable, 2 years. However, the restraints as to geography and scope of activity are overbroad and should not be enforced. I'll address the non-compete and then the non-solicitation agreement.
Elena, you know, in the other case we had, the Jones case, you took the exact opposite position on geography.
Excuse me, Mr. Dunn, if you would allow Ms. Ackles to finish her arguments, and please address your comments to the court when I come back to you. Thank you, counsel.
I apologize, Your Honor.
Thank you.
Turning back to the non-compete, Your Honor, it's overbroad as to geography. The non-compete states that it applies in any territory in which Mask Up ever solicited customers or ever sold garments. Your Honor, the Andrews affidavit in paragraph 5 says that Mask Up sold masks throughout the world. A geographic limitation on the entire world is no limitation at all. It's well settled law. The cases are cited on page 4 of our briefing, that a non-compete that covers an area where the employee did not actually work is overbroad and unenforceable. One of the key cases on that is the Camerata case from the Southern District of Texas, applying Texas law. Turning now to the non-compete as to scope of services. It's overbroad, Your Honor. The cases are cited on page 6 of our brief. It's well settled that without a limitation as to the type of business the employee performed for the employer, the non-compete is overbroad. And that's exactly what we have here. A hallmark of non-compete law is that a restraint on trade is not enforceable if it's broader than necessary to protect the legitimate business interest of the employer. That's the Haas case, the Texas Supreme Court case. It's one of the landmark cases on this issue. Your Honor, in this case, Mask Up only manufactures and distributes masks. So a restraint on trade that applies to the provision of garment design services is overbroad and unenforceable. Mrs. Hampton's current work for CYM is as to their jeans venture only. She's not interfering with Mask Up's business goodwill or using their confidential mask-related information in her new role. This non-compete is tantamount to an industry-wide ban, which is not permitted under Texas law. Ms. Hampton is a single mother with a special needs son. She's the sole breadwinner for her family. She has to work, Your Honor. This non-compete would be a ban for her to work in the industry, which is why non-competes written like this one are void against public policy.
But excuse me, Ms. Ackles, it is true that the contract that CYM, her new employer, secured with Nile.com, that contract is in fact for the production of cloth face masks, and Nile was a company that she did work for while she was employed by the defendant, correct?
That is correct, Your Honor. The solicitation at issue that was referenced by counsel for Mask Up related solely to her new rhinestone jeans venture. This is in paragraph 6 of the Andrews affidavit. There is no evidence of any solicitations that relate to mask making, which is the only business that Mask Up is involved with, Your Honor. Turning back now, Your Honor, to the non-solicitation agreement, we've now addressed the non-compete. Turning to the non-solicitation, it is overbroad as to scope. And first, I'll address services. For this, it says, I will not solicit business for garment design services. Again, Your Honor, Mask Up's business is solely related to the manufacture and design of masks. And this is overbroad to include a non-solicitation that applies to any garment design service anywhere in the world is simply overbroad. She did not provide wide-ranging garment design services to Mask Up. She provided them as to masks only. So it's broader than required to protect the interests of Mask Up. Now turning to the scope as to the definition of customers in the non-solicitation agreement. The non-solicitation agreement applies to any current Mask Up customer or any Mask Up customer about whom information exists within their electronic databases or about whom Mask Up has institutional or internal knowledge. Your Honor, I think maybe the Dallas Court of Appeals said it best in the U.S. Risk versus Woods case, which is cited on page 6 of our briefing. And they said, quote, a restraint on client solicitation is overbroad and unreasonable if it extends to clients with whom the employee has no dealings during his employment, end quote. That's exactly what we have here, Your Honor. This is not enforceable. Ms. Hampton respectfully requests that the application for the temporary restraining order be denied because Mask Up has failed to carry its burden that it can show a substantial likelihood of success on the merits. And Your Honor, Ms. Hampton also opposes the request for expedited discovery, and I can address those arguments now or after counsel for Mask Up has an opportunity to respond.
Counsel, you have about a minute remaining on your time, so you may tell the court the basis of your opposition to the request for expedited discovery.
Thank you, Your Honor. First of all, a request for expedited discovery under proceedings such as this is not required. It's a matter of discretion for the court. And in this case, it should not be granted. If a TRO is entered, Your Honor, Miss Hampton will not be permitted to work for the next 14 days until a temporary injunction hearing is set. She'll already be out of work, and this is just too expensive. She can't afford to take multiple depositions and be flooded with different discovery requests. Your Honor, MassGup brought this lawsuit and requested this injunctive relief. It's their burden to prove it. Their application had to be verified by their corporate representative. So I don't know what could possibly change between now and the injunction proceeding. If the corporate representative wants to take the stand and testify at the injunction proceeding, he's certainly able to do that and state his grounds, and we will be able to cross-examine him and show the court why, as a matter of law, these restrictive covenants are not enforceable under Texas law. Thank you, Your Honor.
Thank you, Ms. Ackles. Mr. Dunn?
Yes, Your Honor, I'm here to answer any questions. Let me go through, first of all, with regard to the expedited discovery, you can't have it both ways. We have literally the Fox that solicited on NUCO's email system all
That's
of the
ridiculous,
clients.
Rogge. You do this in every case.
Ms. Ackles, again, as I'd asked Mr. Dunn to be respectful of your time, I'd ask the same of you, and again, address your arguments only to the court. Proceed, Mr. Dunn.
So the bottom line is, she is now at NUCO using our trade secrets and sending that information out. So we want that discovery right away. We just lost a $50 million contract that apparently turned into a $100 million contract. So we have devastating, and it cannot, I know you mentioned, can this be compensated by money? No, it can't, because it involves our reputation and our ability to get future jobs, and that harm is irreparable. But setting that aside, we have significant harm immediate now. And so we want that deposition now. I respect Alana saying, oh, she's only doing jeans, but we don't know that. And given the fact that she solicited our customers and took our trade secrets, which when you go and look to the customer list, it says this is property of Oldco. You're not to take it. You're not to duplicate it. You're not to download it. You're not to forward it. She did that in direct violation of her contractual obligations. And besides the contract, under the common law, she has a fiduciary duty not to take, steal, misappropriate, or use our trade secrets. So we need her deposition right away. If they want to put it off, then she needs to agree to a TRO where she leaves Oldco's premises and does not work for Oldco until we can complete this expedited discovery. Frankly, she can't have it both ways. So
Mr. Dunn, excuse me a moment,
Yes,
a couple of things. First, with regard to the court's question previously about why there is not money damages are not an adequate remedy at law, and why you seek to have the court martial its equitable powers, what is your response?
My response is she's contacting our current clients. That information has been put onto NUCO's server, and that, interfering with your clients is irreparable harm. Then guess what? It's going to be difficult to prove that somebody went to NUCO or went to some other company and didn't buy with us. So there's no way we can prove that harm. So that's the answer to that question, Your Honor. Then
secondly, as it relates to the allegation in support of your trade secret misappropriation claim that she appropriated improperly confidential and trade secret information, what are the verified allegations that support that?
Well, everybody stipulated that our trade secrecy program is robust. We had a list of clients on our internal database that was password protected, that you had to click on to get access to it, that you agree that this is company property and you're not to have it downloaded, misappropriated, take it with you when you leave. So she made those agreements. So that is our list. And by the way, it's not just a list of names. It includes buying proclivities. It includes their kids' names, their cell phone number, things that are not a matter of public record, including where they went to school, what their outside activities are. They like opera, they like football, they like dance, whatever it is. So that it's not just the names and contact information, it's non-public information that was acquired, refined, and improved over years. Turning now, Your Honor, to the global issue, counsel says, oh, this is too broad. It should only apply where she did work. Well, I call the court's attention to the case we cited, ironically called CSI versus Andrews, which was the Northern District of Texas. Judge Reed O'Connor noted that CSI's business was global in nature. And we're beyond the good old days when I first started practicing law of brick and mortar. And all the non-competes used to say you can't compete within 25 miles of a brick and mortar. Well, guess what? We're in the 21st century and business is virtual. Business is no longer sustained or required by brick and mortar operations. So it is, per Judge Reed O'Connor's, something that that is enforceable. Most importantly, setting aside the issue of whether or not the non-compete is overly broad versus how necessary that is, there's no doubt she violated the non-solicit. There's no doubt that the very next day, the first thing she did is use our confidential list and send out emails. It's one thing to compete, Your Honor, and I get the tearjerker story of, oh, she's a single mom. She still has to comply with Texas law. She still has to comply with her word, her bond, her contractual obligations, and do things the right way. There's a right way to compete, and there's a wrong way. And if there was ever a case of wrong way competition and non-solicitation with an arch rival competitor, this is the case, and my client will suffer irreparable harm unless we get the relief that we're seeking and expedited discovery. And I've reserved some of my time for any questions you might have, Your Honor.
Thank you, Mr. Dunn and Ms. Ackles. Thank you for your arguments. The court has had the opportunity, as I had indicated at the outset, to review the verified pleading, which includes a detailed, frankly, affidavit from Ms. Andrews in support of the application for relief today, and also have had an opportunity to review the briefing from the other side. The court is persuaded that the TRO ought to issue, at least in part. I do have concerns, despite my great respect for Judge Reed O'Connor, I do have concerns that this particular covenant not to compete is overbroad, does not have geographic limitations, does not have the level of specificity that I think is required so that it is not an undue restraint on trade. On the other hand, I am concerned by the pleading that she is violating the non-solicitation clause. As I understand it, Nile.com wasn't a customer at her predecessor employer at Defendant's Place of Business. She worked with that customer and, of course, then went and solicited business. The non-solicitation clause states that she will not solicit business for garment design services from any current mask up customer or from anyone that she contacted regarding the provision of those services. And the court is concerned by these allegations that she's violated that. So the TRO will issue to restrain that. Finally, as it relates to the request for expedited discovery, the court is inclined also to grant the request. The only thing, Mr. Dunn, I will need you to modify your order so that that is a reciprocal order. That is to say, they will get the opportunity to conduct discovery as well in the interim as you both prepare for the temporary injunction hearing, which will be set 14 days from today. Is there anything further for the court this morning?
No, Your Honor.
Thank you, Your Honor. May I request that the discovery be limited to 15 interrogatories and 20 requests for production so as to not overburden Ms. Hampton?
Certainly, that
Your Honor,
seems like a reasonable limitation. Mr. Dunn, something else for the court's
Well,
consideration?
I was just going to say, rather than pick out a artificial number, that you give us 1 day to confer. I work well with Alana. We've had other cases, and if we can't work out a reciprocal and it would cut both ways, limit on discovery, then she could submit a quick 1-page letter brief of why it should be 15, and I could say, hey, why it needs to be 17.
All right, thank you for that. The court's inclined towards the granting of the request for the limitation to be 15 on each side, interrogatories and requests for production. Also, each side will be given the opportunity to do 1 3-hour deposition record time, and the notice of the discovery, the deposition with any ducis tecum will need to be given at least 3 business days beforehand. Is there anything else for the court this morning?
No, Your Honor. Thank you.
No,
Thank you, counsel. Thank you. You both are excused. Thank you.
All right, that concludes the mock TRO argument, which was truly excellent and extremely authentic. I feel like I'm ready to run through a wall for the plaintiff and for Masca. So thank you. And I'll welcome back Magistrate Judge Horan for our panel discussion. And I'll start with you, Judge Horan, not specifically about TROs, but how do hearings like this, pretrial hearings on motion, how would they differ from state court with Judge Parker or federal court with you?
Well, the conduct, and I think maybe we'll talk about that a little more, but in terms of the nuts and bolts of a hearing, it wouldn't really be particularly different between federal and state court. I think the biggest difference between federal and state court here in Dallas is when and in what context you're likely to have a hearing or oral argument at all. Obviously, in both courts, where evidentiary hearings are necessary, then we're going to hold evidentiary hearings. But and I don't want to steal Judge Parker's thunder on better explaining her court and the rules governing it. But in federal court, in the Northern District of Texas, the local rules provide that there won't be oral argument on a motion unless the presiding judge authorizes it. So the default runs, as I understand it, the opposite direction from how it is in state court. And so a great many motions in Dallas federal court are resolved purely on the papers. Again, that wouldn't be the case with evidentiary hearings, where an evidentiary hearing is necessary. And it really varies by the presiding judge or the judge who's handling it. If it's a magistrate judge handling a motion on referral, I tend to want to have oral argument where, obviously, in any case where I feel like beyond the briefing, some discussion of a legal issue or say the summary judgment record or something with counsel would really benefit me in trying to resolve the motion. But I also find them really helpful in cases or in the case of motions that have sort of a live dynamic going. So, certain motions on if I were to grant the continuance, for instance, we're having the lawyers there and being able to work out exactly what the dates ought to be or something like that would be helpful. And I like to have oral argument on discovery motions, particularly where I feel like it'll be helpful, or there's a big volume, and just getting the lawyers together and talking through them, in sort of a live dynamic would be helpful. But so again, much depends. I mean, often hear at seminars regarding practice in our court that it's really important that your briefing be excellent, because that's likely to be all the court is going to resolve the motion on. Flip side of that isn't true. You shouldn't tank or phone in your motion, your briefing just to get oral argument. That's not going to put you off on a great foot either. So yeah, I guess that's a long way of saying the default is not to have oral argument, or it's certainly not guaranteed or promised, and it just kind of depends after that.
And Judge Parker, what about in Dallas State Court? When does oral argument occur, and what is kind of your view on that?
Sure. As Judge Horan alluded to, it's pretty much the exact opposite. The default here is that for most motions that are filed with the court, unless it's something where there's no one on the other side, such as a motion for default judgment, or there's no opposition, and that's reflected in a certificate of conference or in an agreed order signed by the other side, it will be set for hearing before the court. Some of us have a very limited submission docket where we will allow for competing briefs to be submitted and the matter to be decided without a hearing. For me, that happens only when I have already had a hearing and perhaps granted leave for someone to supplement the record, and then I will set it for submission hearing docket for the second go around, so that we can conserve the resources of the parties, to not have their counsel have to come and present again. But the court has a specific date and time on which I'm going to consider whatever that supplemental evidence is. So the default here is that you'll get oral argument more often than not on opposed motions, with some courts allowing for limited submission dockets.
Great. And Judge Horan, with the default kind of flipping in federal court, how do you treat a specific request for oral argument? And is there an opportunity for young lawyers, we are the Dallas Association of Young Lawyers, to get involved? How do you view that when a younger attorney or a less experienced attorney will be involved at oral argument?
Let me take the first part of your question first. Generally, I certainly have found myself in situations where one or both parties to a motion have requested oral argument, and I just don't think it'd be helpful, or the timing of it for some reason just doesn't, work out. Otherwise, though, I tend to grant requests for oral argument. So sometimes the question gets put at CLEs, well, what's the best way to get oral argument or a hearing? Well, the best way in the Northern District of Texas is to ask for it, and it's separate in a request, in a separate motion or a separate document, or somewhere prominently in your motion papers. It can be difficult if it's buried, not even under a separate heading, on the 10th page of a 12-page, motion or even response. A lot of us will look at things relatively close to when they're filed, but if you don't, you really want to call that to the court's attention. If you really want an argument, ask for it, and ask for it in a very clear way. With regard to young or junior lawyers, when I came on the court, followed what Judge Lynn and a few others are doing, and many of my colleagues are doing as well, which is in a lot of my standing orders or briefing orders, I make clear that it's a very much a plus factor for me if a more junior lawyer will be who's worked on the matter will be arguing, or I'm actually happy with split argument, or I'm happy for lawyers to split arguments in some way that makes sense. So we'll be presenting at least one part of the argument. That is very much a plus factor for me in terms of granting that opportunity, because I do think it's really critical for all lawyers to get opportunities to argue in any kind of court, but certainly federal court, where the opportunities can be more limited given our default. And so, yeah, it's that in addition to asking for it, if you ask for it and say that, it's very likely you're going to get oral argument.
All right, let's turn to our experienced attorneys, Elena and Raghi. And since Raghi started off the TRO hearing, I'll start with Elena. On what kind of issues or topics or motions would you specifically request oral argument?
So again, the answer to that is different in state versus federal court. So in federal court, if there's a particularly nuanced issue, or perhaps it's a new question of law, or maybe we're asking the court to change the law on something, I would request oral argument on something like that. In state court, again, we typically have oral argument on most things. And I think we're going to talk more a little bit later on sort of what are best practices there for presenting those arguments. At a pretrial hearing in state court versus just maybe like a motion for summary judgment or a motion to compel. But in my experience, most things are argued at the state court level and rarely get argued at the federal court level.
And Raghi, what's your perspective?
I almost always request oral argument. I think I do well on my feet, and I think it's an opportunity to engage with the judge. I also like to bring junior lawyers along, and they don't carry a briefcase. They argue part of it if the judge will let us split the argument. The exception to that would be if we have case law directly on point, and I think the judge is going to read and understand that, then I might not request oral argument, so that opposing counsel doesn't have the opportunity to throw some Hail Mary or some smoke and mirrors argument to try and confuse the issue, and especially if I think our briefing is superior to theirs. But generally, I like oral argument. I think that's part of being a lawyer. So, and I love, we don't have enough interaction with the judges as it is. So I just truly, that's one of, to me, you got rehearsal and I'm on stage. I like to be on stage. That's, the hard work is putting together the briefing and thinking about it. The fun part is getting to perform. So that's just me.
Yeah, and I should say
Great.
we almost always request it. We just don't always get it in federal court. So it's usually just when there's a nuanced issue or a new issue of law that we get the oral argument in federal court.
Great. We have a question from one of our attendees for the judges. How often do judges decide an issue based on oral argument? The attendee says, do judges have a decision in mind before hearing oral argument? And maybe we'll start with Judge Parker, since we got a ruling from her on that motion for a TRO.
Sure. Such a good question. And let me just say that for me, being prepared for the proceeding means that I come onto the bench with a sense of how I'm going to decide something, leaving open the possibility that something could be said, or my attention could be drawn to an aspect of the record that I didn't appreciate when I was reading it on my own that could change my decision. So I always leave mental room for the possibility that I didn't read something as clearly, or the briefing didn't come across as clearly, or something, and my decision could change. But because we do have to make our decisions based on the record, which often is the clerk's record, the things that have been filed, and not the court reporter's record, the record that is made in front of you in a courtroom with the court reporter, because we have to make our decisions based on the record, then oftentimes I come on the bench with a sense of how I'm going to rule based on the record that I've read, because I have more often, 98% of the time, I have read everything that has been filed. But of course, people file things late and untimely, and so sometimes everything doesn't get read. But yes, definitely come on to the bench with a sense of how you're going to rule, leaving open the possibility that the lawyer could augment something in their argument in a way that you didn't appreciate, that might influence a different outcome.
Judge Rand, what's your view on that?
Actually, Judge Parker just summarized really well kind of where what my experience has been, obviously, and I know she is as well, leaving aside a situation where you're going to have live testimony, and then, you're going to hear that and you don't know what that's going to sound like. But yeah, I mean, I try and have read everything and be prepared in advance of oral argument as much as I can. I do come out with questions. That's really where I want to focus oral argument on motions and get my questions answered. I guess I'd just say I almost always go in with at least some sense of where I think it's going to come out. I have been surprised over the course of 8.5 years how often I'm wrong after it's all over, because and that's great, right? I mean, that's why why we play the game. So in my experience, when I do have oral argument, it very often really matters.
And turning back to our practitioners, Elena, maybe you could start. What are some differences between the pretrial hearing we saw and perhaps an argument to an arbitrator or to an appellate panel?
Yeah, so as it so happens, a lot of employment cases are in arbitration these days, other than when we're seeking injunctive relief like this. And so you just have to sort of be thinking about that the arbitrator is also your ultimate fact finder in the case. And in arbitration, it's fairly difficult to get an arbitration award overturned, but one of the ways to do that is if the arbitrator excluded key evidence. So almost everything comes in arbitration. So you have to be ready for that. So unlike in state court, where you might have motions in limine to exclude certain evidence or information from the jury's purview, and the judge is making those decisions, but the jury, the ultimate fact finder, is not hearing any of that. There's a certain strategy there. Whereas in arbitration, or this happens to in a bench trial, or in just a hearing on a dispositive issue, you're arguing all of the same things to the same person. And in arbitration, you just have to be prepared that most things are coming in, and know that, and that to a judge or to an arbitrator, either way, you're arguing to an experienced professional, which is very different at times from arguing to a jury, which is typically full of lay people, right? So those are different. And then did you ask me about the appellate court argument as well, George? Yeah, so
I did.
Yeah, so at the lower court level, you're dealing with the exhibits. You might have an evidentiary hearing. You're putting on witnesses. So you're building the record, right? That's a little bit different than what you're doing at the Court of Appeals, where you already have the record. And so you're really it's so important to have a mastery of the record and a mastery of the case law. And one thing that I do for those kinds of arguments is have kind of a cheat sheet, one a case law cheat sheet, and the other is a record cheat sheet. And it's got all of the key cases that I need to rely on or distinguish, and it might have just a little line about what the case was, who the players were, what the outcome was. And then similarly in the transcript I've got, or for the record, I've got the cites to the record with all of the key factual information that I need. And that's really great, where if you get a question from the panel, from one of the judges, and they ask you about, well, this isn't like that case because of such and such, or tell me why that's so. You can say, well, Your Honor, the Texas Supreme Court held and such and such and such and such, and the facts there were this, this, and that. Similarly, you can say something like, Your Honor, there was testimony, it occurred on, page 225 of the record, wherein the plaintiff testified X, Y, and Z, and you've got it there. And so you want to make sure you have such a mastery of the law and the record and be able to present that to the judge.
Great. Raji, how would the argument we saw in support of that TRO differ if you were in front of a jury or an appellate panel?
Well, before I forget, I just wanted to compliment Elena, and this is very relevant since we're doing so many virtual hearings now. When I thought it was very rich and professional when she said, "May I share my screen with you, Your Honor?" So I just put that in my toolkit. I try to, in trials and hearings, make it look like we're all in this together. And I will typically say to a jury, let's all turn together to Exhibit 7, page 7. So it's like we're not excluding anybody. I do agree. I want to echo what Elena said, about segmenting your arguments on an appellate court or even in front of a judge. And I use these 5x7 cards. And so I'll have printed on there the key arguments. And I also use this for whatever it's worth for hearings, for the clients to communicate and pass me notes. And if you have, and when she was making her arguments, I was doing my rebuttal arguments on these cards, because if you're flipping through a yellow legal tablet, it makes noise, it makes you look disorganized. And frankly, if you've got two arguments on one page, in the heat of the battle, you may forget it. Whereas if you have each argument or rebuttal argument on a 5x7 card, chances are, okay, I've done that when you put it away. I don't think, just generally speaking, that there's a whole heck of a lot of difference in appellate argument, other than you have probably a more sophisticated audience. But I like to say that judges and arbitrators are people too. They all have the same biases, prejudice, life experiences that are going to impact their view of the world and the law. So I tend to do graphics, and I know the PhDs tell us that something like 84% of persuasion and retention is based on visual, not the words you write on the brief, not the words that come out of your mouth and hearing, but visual. So I use a lot of visual. You have to be careful. The more sophisticated the audience, the more it looks like you're being kitschy or talking down to the judge like, hey, I'm not a juror. But the reality is they are. So one of the things I put in here, which I'd be curious to see what the judges thought of, or Elena thought of, for my smoking gun, I put a picture of a smoking gun. Is that too kitschy? Did that offend Judge Parker or Judge Horan? Did you think, hey, it's effective, or hey, fine either way? Certainly with a jury, I would have used that smoking gun. I probably wouldn't use it with an appellate court, but I certainly would use it in a district court in the heat of a battle to bring home the image of smoking gun. So,
Judge Parker, what did you think? Was the smoking gun effective? Is that something you would like to see?
Well, it didn't offend me, but it just didn't influence me. I thought, certainly it drove home the point that was his impression of the email that was sent. Maybe it made me look at the language that much more because he feels very emphatically that this is a terrible email that she sent. And so maybe it does. I may not be conscious of the level of influence that it had over me, but consciously, I was already there. He had made the point quite emphatically. But I will say this, all judges are different. And so I don't think it hurts anything to do that because, like I take the time to really try to read every record of the matter that's in front of me. But some people skim things. Some people rely on the lawyers to draw their attention to it. So maybe that image makes another judge go back and say, let me look at that email. How bad was that email? And they might have just skimmed it. So I don't see any harm in including it because you never know what type of judge you're in front of or what kind of time time they had to invest in the record. And remember, this was a TRO. So not only is it, you know, an emergency a proceeding, but you may be catching the judge coming out of trial, on a break from trial. You don't know. So I think Mr. Dunn is right to try to bring home the point every way that he can as an advocate.
Judge Horan, what's your perspective? Should we AUSAs bring in clip art images for our pretrial arguments into the judges here at the court?
That's a loaded question.
Right, yeah,
Pardon the pun.
Metaphorically and literally.
I don't think my perspective is really any different than Judge Parker's on that. I mean, I obviously was watching as an audience member and not trying to, you know, make even a mock decision in the hearing. But I do think that in very targeted ways, both in briefs, including very much at the trial court level, and oral argument as appropriate, that certain graphics. I mean, if there's like a real picture of something that really, you know, is the real thing, I mean, there's no substitute for that in a variety of settings. And even graphics, tables, that kind of thing. I mean, if there's some way that a visual depiction or you know, sort of slicing and dicing of data or information, it really can be more persuasive and illuminating, you know, to present that rather than just saying it or just, you know, presenting raw data. So, I mean, I would encourage you. I mean, I think we're seeing lawyers do this more and more. I mean, when I first started practicing, just not even that long ago, and certainly in appellate briefs, you know, including graphics and tables or, you know, including images was pretty uncommon. I mean, certainly outside of, you know, like a trademark or something. You know, now I think it's much more common. I think lawyers have figured out that it's a real valuable tool in the toolkit. And so again, I'd say as long as it's not overdone and you've got a good, you know, you have your own, you know, case you've made in your head for why this is, you know, a more effective way to bring something out. I think it's can be quite effective. And yeah, it, you know, breaks up the text and you know, it's more visually interesting, obviously. So when there's a good reason for using either a photo itself or some image from a record or some, like I say, some table or graphic, I think it's a good idea.
Yeah. Now, let me just add one other point about that, because, you know, I've had cases where I felt that people put things in front of me to try to, I guess, get shock value or make a point that it was very offensive and jarring and upsetting in some instances. You know, we deal with serious death cases on a regular basis. And I had a case where a man, unfortunately, was working on a construction site and his hat fell off. He leaned forward to reach for his hat while he was sitting on a backhoe, and the top came down and chopped his head off. And in the middle of a summary judgment hearing about whether there was actual constructive knowledge, counsel said, "Your Honor, may I approach?" And I'm thinking she's coming up to give me a case or the proposed order. And she just puts this image of this beheaded man on a construction site and just lays it on top of the bench. And I mean, it was quite jarring. So that sort of thing doesn't work. That doesn't, you know, get you anywhere, and you probably are going to distract your judge. And so there are instances where you may need to do that. I've had other wrongful death cases where it's important to know whether or not the person was conscious of the fact that they were dying. And there are things in the image that perhaps shed light on whether they perceived that their death was imminent. Those images have to be shared. And what I just appreciate is just the slip cover sheet on top of that just has the warning both to the court reporter, to the court. A graphic image is beneath this. And then the court can prepare itself, and the court can choose when to look at it and what setting to look at it. And so I would just add that as a point, a practice tip for folks who may need to sometimes share images that are graphic.
Elena touched on this when talking about her cheat sheets for appellate argument. But Elena, how do you, and I want to turn to the next topic, which is preparing for the hearing and the role of junior attorneys. Elena, how do you go about preparing for a pretrial argument like the one you just presented?
Yeah, so kind of depends on what the issue is, right? So, and who we're arguing to. So I know that Judge Parker always reads the briefing and is very familiar with the briefing. So if I was appearing before Judge Parker, I would try to only sort of hit the high points, right? Because I don't need to go through every single point of my brief. I know she's read it. You know, if I feel like there's a chance the judge isn't as familiar with the briefing, or I know they're in the middle of a trial, so they probably didn't get a chance to really pour over it, I might spend a little more time going through each point. But if it's like a motion to compel, or let's say objections to a motion for summary judgment, one tactic that I think is really effective, rather than just sort of going through each one, it's to group them by category. So instead of saying, you know, motion to compel on, you know, interrogatories 2, 3, 5, 7, you would group them. And so if it was an objection to motion for summary judgment evidence, you might group them by categories of objection. You know, these documents are evidence of subsequent remedial measures that should not be considered by the court. These documents are unduly prejudicial because of XYZ, you know, whatever it is. And that would happen in like a pretrial hearing too. If you were trying to pre-admit the documents, I would try to do it by category, which can be a really effective way, an efficient way to tackle those. And then in terms of, you know, prepping junior attorneys, I think it's great that the judges have really made an effort. And I've seen a sea change in this in recent years, where they really want young attorneys to get experience. And I think it's incumbent on us as more senior lawyers to give those opportunities to our associates. I always say I don't want to show up and just have the associate carrying the briefcase, right? I mean, they should have some active role. And it's great to hear that several of the judges are becoming more open to splitting argument, because certainly sometimes we're at the behest of our clients who, you know, want the senior attorney arguing, but if there's one smaller sort of tangential issue that maybe the associate could take, I think that's a great opportunity. And then it's our job as senior lawyers to prep them and make sure they're ready and be the safety net if something comes up.
Judge Horan, Judge Parker, you know, I've often heard one horse, one rider for oral arguments. And I think Judge Horan mentioned having issues broken up and having that as an opportunity for junior lawyers. How do you view that? Do you view that positively, or are you of the view that one horse, one rider for oral argument?
I view it positively. The only thing that you know, I think probably I now am known for is that if you are giving someone the opportunity to do the argument, then let them do the argument. You know, sometimes the more senior lawyer will stand up and say, when the younger lawyer gets in a tough spot, maybe the court has posed a question that they've just got to think about for a moment before they respond. And the senior lawyer will rise and say, Your Honor, may I address the court on this point, and then sort of try to take over the argument. I am known for responding respectfully, counsel, no, you may not. Please be seated. And I do that because I know that it's that moment that's going to give that lawyer the opportunity to learn how you get your legs underneath you. How do you respond if you don't know the answer? What do you do? And if I let someone come in and take over, then they're going to be deprived of that learning experience. So I welcome it, but once everybody's in the gate, then they're on their own to do. You can pass them a note. You may ask for a moment to confer, but you don't get to take over their argument.
Yeah. And piggybacking on that, Judge Parker, I think it's also a good practice tip, you know, for the younger lawyers. If you ever do get in that situation and it's deer in the headlights, because ultimately we have to be zealous advocates for our clients. And if you really don't know how to handle it, ask the judge, Your Honor, may I have a moment to confer with my co-counsel? Yes. And I'm pretty sure the judge is going to give you that opportunity to professionally just kind of confer for a minute and then respond.
That's exactly right. Yes.
And I thought Elena had a great point about combining the issues of motion to compel. And I probably shouldn't give this trade secret away, but I now, in all the discovery I send out, I have headings. And one would be mitigation of damages. One would be, you know, similar occurrences, similar discrimination. And then when we go to motion compel, instead of judge, oh my goodness, we got 80 things to compel, I'd say, Your Honor, there's basically 10 topic areas and there's subsets. And once you rule on the first one, it's all going to fall into place.
Yes, yes.
And then lastly, I'd like to echo what Judge Horan said. I do think it's very powerful setting aside demonstratives to put actual evidence in the brief. And for example, I don't spend a lot of time paraphrasing cases. I put exact block quotes and say, Your Honor, this isn't me interpreting the case. This is what the court said. And way back when, long before electronic filing, I had the privilege of representing an African-American woman against the city of Greenville. And as you know, you have to prove under Monell a pattern or practice of discrimination, intentional discrimination by the government authority, which is hard to do. And I found, I forget how, some postcard that said, well, that said this sign was proudly displayed by the city of Greenville on City Hall until 1988 or whatever. And it said, welcome to Greenville, the blackest land, the whitest people. And I just put that in my brief. I remember taping it and sending it off the federal court and say, you want to see Monell met? Look at this picture. Boom. That's all I said. And you know, that can be powerful to give direct evidence and direct quotes.
Yeah, that is. And I love it when it's in the brief and the court doesn't have to go flipping back and forth, especially in state court where there's nobody else but us, and we've got to digest the record. So, yeah.
Rocky and Elena, as partners, how do you view requests from your more junior colleagues to handle oral argument on a motion that they worked on or a brief that they worked on? And we'll start with Rocky.
Well, I'll give anybody, whether it's an associate, a partner, a paralegal, paraprofessional, as much responsibility, duties, and obligations as they prove they can handle. So if I had some concern, I might say, let's do a mock argument, and that at least is an educational and training experience. And if I think they're up to the task, absolutely. And then I would have my note cards handy, and I might have to resist passing them notes, which I want to do, but I think the only way you learn is by doing. And I was blessed because I came in licensed. So I was one of the few people in my class at Thompson Knight that was licensed. And so I got a lot of frontline experience. And I tell you, there is nothing when you're on the line and it's you failing or succeeding, there's nothing that motivates a person to do the job the right way. And again, you just learn by doing. You can't learn how to try a case. In fact, I don't think you take a good depo till you've tried 8 or 9 cases and you see in action how you should have cinched up this point in a depo. So I'm a big believer in giving people as much experience as they can handle. One of the nice things too, for the younger lawyers, I did a lot of pro bono work when I started, and I got some trials out of it and I got depositions out of it. So I highly encourage, if your firm will permit it, that you go out and you do pro bono, because that's going to give you experience. And maybe you talk to your firm and take on, some case. One of the things I'm doing is, and I checked ethically, I think this is correct. I say to the client, if you go through 3 days of trial, we'll rebate $50,000 of our fee. Okay, we'll give you a discount so that we can get trials. And it gives the client that wants to go all the way to trial an economic way to do it, because as you know, trials are so expensive. So those are some of the things we try to do to get experience for not just our younger lawyers, but our older lawyers as well.
Elena, how do you suggest a younger lawyer approaches a partner about handling a piece of oral argument on a motion pretrial?
So the first thing, I guess, it's great when young associates ask, right? So the worst thing we can say is no. So always ask. I mean, that's kind of how I got trial experience as a baby lawyer. Was I would actually look at I was at a different firm then, but I would look at the trial docket, and if someone was going to trial, I would go into their office, way in advance. And I'd say, I see you have a trial coming up. What can I do? Can I go with you? Can I watch? Can I argue motions in limine? Can I organize the exhibits? It was like, what can I do? And the partner loved that because I was taking work off of her plate, right? I was making her life easier by doing that, even if it was just handling something small at the hearing. And so be aware of what's going to trial within your firm and just ask. And then also have some sensitivity, I guess, to the size of the case. So in a multi-billion-dollar commercial case where someone's business is on the line, you're probably not going to get as many opportunities as a small case, right? And so that's why, similar to what Rocky was saying with the pro bono work, which is an excellent suggestion, you might also consider taking on some smaller cases. It may not always be the really sexy multi-billion-dollar bet the company case. Maybe it's a small creditor's rights case or a lien issue, but you're going to get to go and handle that, right? So also consider diversifying your practice a little bit. to take on some of those smaller cases where you can be the first chair. You can take it start to finish. It's gonna be your baby. And once you've done that with the case and taken it cradle to grave, it's just such an awesome experience because you really do see the life cycle of the case, how the deposition you took is then presented in court later, how it's used at an MSJ hearing, how it's used for impeachment later at trial. When you've done the whole life cycle, that's really instructive for a young attorney.
Great. Well, we're running a little bit over our time, but this is a ton of super helpful stuff for our members and the rest of the attendees. But I want to touch on a couple topics before we leave and hear from the judges, their perspective, starting with Judge Parker, about what's effective at oral argument pretrial and perhaps what's not.
Well, one of the things is what Mr. Dunn talked about earlier. If you have set your brief up in a way that allows me to use it during the proceeding, that is to say, you could have numbered it sequentially, the pages from the first page of the brief to the last page of the exhibit, you've numbered every page sequentially, so you can tell me, Your Honor, if you turn to appendix page 1 or record, whatever, I can go directly to it. And that's especially true in this environment where we're having to use PDF documents. So if you're able to say it's PDF page 46 and it happens to be exhibit C and I'd otherwise have to click over to it, that's very, very effective. The other thing is, for when you come accompanied by co-counsel, for the lawyer to not be distracted by the counsel that they've come with. And this is for older lawyers, and the younger lawyers will just have to have these conversations about the passing of notes. It can't concentrate on what the judge is asking me if you are passing me notes at the same time. So if you want us to take a time out, then ask the court for a timeout, but trying to entertain what's happening on the side of you, plus pay attention to responding to the court. It's distracting for both of us. And so that tends to not be very effective. But the most important thing is how you put that record together that allows me to quickly be able to turn to the actual evidence that supports the arguments that are being made.
All right, Judge Horan, what about you? What's the most effective and perhaps not effective way to handle oral argument?
Well, again, in non-evidentiary oral arguments or non-evidentiary hearings in federal court, I mean, particularly because it's not the default and they're sort of the exception to the rule. I think with most of our judges, you'll find that we come in with knowing what we want to ask about and explore and find out. And as I said, I mean, I tend to conduct those things largely like, kind of like an appellate oral argument, where, I would say at the outset, I've got questions for each of you. And if something that you wanted to amplify or add beyond the briefs, I hope you'll get a chance to, provide that and answer my questions. But if not, obviously I'll give you a chance at the end. But so, I mean, I think knowing that, and not expecting to come in and sort of give a 15 or 20 minute, oral sort of summary of your briefs, which I've already read and digested, but, having focused on what are likely to be the things that are the biggest issues for me to resolve, that I'm likely to ask about, and then answering those questions directly is by far the most effective way to handle oral argument in front of me, and I think in front of most of my colleagues.
I think also, Mr. Pattis, if I could just add one last thing about staying composed and not getting defensive and adversarial with the court. Sometimes, I'm asking questions of you that I know the answer to, but I may just be asking it because I've asked 5 questions on the other side. I realize I haven't asked any questions of you, and that might give the appearance that I'm not being impartial, and that's not my aim. So I know that a large part of people having a good experience in court is the perception that it was an impartial proceeding. So I may just be throwing some questions your way for you to respond to so that it seems a bit more balanced. It appears more balanced, which I have to concern myself with the way that it appears. So just staying composed, not getting adversarial and defensive in responding to questions from the court, I think is also important.
All right, one last question for Elena. What is the biggest mistake you've seen in oral argument?
The biggest, well, Raghi and I demonstrated some of but interrupting, let me just go down sort of maybe the top few. Interrupting the court, being condescending towards the court, interrupting your co-counsel, personally attacking the other side. Let's see what else. Overreaching, overselling what the facts are, or overselling what a case says. That's a big no-no, and I see that a lot, especially with young lawyers, which is why sort of the actual excerpts from an exhibit or the excerpts from a case there on the page, the quoting can be much more effective than, you know, my interpretation or my sell of what the case said. I think those are probably the top few that come to mind.
Well, thank you. This concludes the panel discussion, which I learned a ton from personally. So thank you very much to our speakers and demonstrators for participating. And also thank you to the rest of the members of the Trial Skills Committee who were behind the scenes helping prepare for today's presentation, especially Zane Plunther and Julie Christensen, and my fellow co-chairs, Alec Ressinger and Barrett Armbruster, who prepared this year's excellent hypothetical. The approved CLE numbers included in the chat. Our next program is the Signature Trial Skills Bootcamp, and it'll be on July 24th on jury trial arguments. So please save the date. Thank you, everyone. And if you have any feedback, I'll leave my email in the chat. Feel free to send me some feedback on how you thought today's presentation went. Thank you.
Thank you,
Mr.
George,
Pattis,
for
thank you
everything
so
you did.
much. That's right. Thank you so
Thanks,
much,
George.
Mr. Pattis. Thank you.
Thank you.
Thanks, everyone.